the information that we're getting, it looks like the immunity under the plea deal applies to drug, gun, and tax crimes from 2014 to 2019, but not any future prosecution. And both sides have reportedly, or at least the information we're getting, have agreed to those terms. So that's just an update.
Yeah, and it's a big update. Obviously, we'll start off with you, Aaron. As an attorney, you know, Hunter's lawyers apparently thought that this was all buttoned up. He would go in, the judge would approve it. He was actually going to come out and make a statement. The fact that now this wrinkle came up, at least, you know, for them, and they were sort of surprised to hear when the judge asked the main prosecutor, would there be possible Farad charges? They said the deal's off. For them to revise it, what do you think's going on there? As put on your attorney hat here for Hunter's legal team, they're just trying to salvage this no matter what, aren't they?
Yeah, of course they are, because they got a very big sweetheart deal. But the question that I have to go back in time before this newest plea deal sort of came up, that Hunter's lawyers over at Latham and Watkins, a white shoe law firm in New York City, AmLaw 100, very prestigious, had their director of litigation, Jessica Bangles, allegedly call the courthouse and pretend to be opposing counsel to remove amicus information from appearing on the docket. Okay, so
that was just yesterday. Yes, this flurry kind of came up.
So this is what happened just yesterday. So how so quickly are we having this cycle move forward that hasn't even really been addressed? This is not behavior that is appropriate for a law firm of this caliber in any capacity. And by the way, every attorney has to take an MPRE, which is the multi-state professional responsibility exam that covers conduct like this. This is not something that happens in the course of litigation. This is completely inappropriate, but I hate to say, it seems like something that's quite common in the orbit of Hunter Biden. So I hate to go back, because I know all of these things that have transpired today are very important, but I think that because the news cycle is moving so quickly, that sort of was sort of passed over and slid under the radar. But as an attorney, that's something that should be looked at very carefully and taken very seriously. An attorney, if I were an attorney, I would say, this is behavior that would get you disbarred.
And sanctions may be on the table for that. So once some people say that is one track. That is one track there, and outside of that is also the plea arrangement. And again, let's bring in Bill too to get your reaction, because we just are getting this moment by moment of what's happening inside the courtroom there.
And it looks like the proceedings have restarted.
The President's son agreed to a limited agreement, so it covers 2014 to 2019 only conduct related to tax offenses, drug use, and gun possessions. So he'll plead guilty to the misdemeanors. But I guess what this also means, the two sides agreed the deal does not shield him from potential future charges. And there could be charges when it comes to FARA, not registering as a foreign agent. Today it was very clear that they said on the record he was being paid from other countries. So again, this deal, even if it's salvage, it's probably not as much of everything they wanted, but it still is pretty good for the president's son, Bill.
Well, we'll see. I mean, listen, a lot going on here. And I will say this to you also as an attorney, I do agree with Aaron on there are ethical standards and duties that we have that may or may not have been an issue yesterday. And we'll find out, the court will find out. But right now we have a new plea deal, right? We're focused on the old plea deal that everybody thought was a sweetheart deal for Hunter Biden. Well, it may not be as good, or it may have been as good, but this makes sense, right? The present issues that they're discussing are now memorialized in a plea agreement that a Trump-appointed judge is going to have to sign off on now after all of this negotiation. But it doesn't foreclose the possibility that if there are new charges or crimes that have not been investigated by the Justice Department, they can bring those charges. So this doesn't end anything. And I say this to you. This makes sense on a number of levels, including related to the gun charge, of making sure that there is a diversionary pathway forward. But this is still subject, particularly now with these new revelations that came out, to the judge's approval. So we'll have to stay tuned and see what happens.
Aaron, your reaction to the fact that this deal now doesn't, prevent future charges. Do you have any confidence, though, because there's been so much testimony from the IRS whistleblowers? David Weiss was offered up this week to come forward after the recess of the House there. But I mean, does this sort of give you, if you're looking at this as an attorney, where this may go now, if there's at least the door is still open for potential charges and more investigating is is happening, or they say it's going to happen. I guess that's the big question there. Do we actually have confidence it will, knowing that the FBI had the 1023, sat on it reportedly, and had whistleblowers from the IRS and did nothing?
Why kick the can down the road for another 5 years? Let's be honest. And when my esteemed colleague on the other side of the aisle says diversionary program, all that really means is a get out of jail free card. It means this is a felony charge that he will serve absolutely no jail time for, which very famous people like Lil Wayne, who's a rapper, is facing 10 years in jail for, and other innocent people who have been charged with this crime and have to pay very extensive legal fees to try to fight these charges, you know, many of whom are African American, but because you're the president's son, you get an air quotes diversionary program. I don't think that really smells right to people who are on the left, right, or the center.
Well, and Aaron, I'm not trying to defend Hunter Biden, but Lil Wayne had a criminal background, and some of these others that you're mentioning they have had criminal backgrounds. So that makes it a little bit different.
Defending Hunter Biden.
What's that?
Last time I was with you, you said he's
I'm not defending Hunter Biden, but it's a legitimate, Aaron, it's a legitimate question, though, is it not? I mean, you can't compare necessarily Hunter Biden to Lil Wayne.
Okay, but I'm using an example. I can use several
others. And I
others.
understand your point. Yeah.
Yeah. Fine. Yeah. But, you know, just the other day I was on with you and you said, we got to give Hunter a pass because he's a drug addict.
I never said that. I never said that. I absolutely, you're putting words in my mouth. I never said that.
I'll pull the clip and send it over. I don't mind. But you did.
Go, please do that. Yeah. And then we could have you on again.
And then 2 days later, cocaine was found in the White House.
What's that?
And then 2 days later, cocaine was found in the White House.
Okay. And so what does that have to do? These are two separate things. What does that have to do with my point right now about the criminal history of rap artists and comparing that to Hunter Biden? That just doesn't, I'm sorry, but I know where you're going with it, but I'm not going to get into a full debate about cocaine.
People that aren't the president's son and therefore are not going to get sweetheart deals like this. Gun charges in this country, especially in liberal states, are taken extremely seriously, and these defendants often face several years behind bars, whether or not they have any sort of criminal past.
I think what we need to go back to is the IRS whistleblowers who worked this case for 5 years have documents saying there were people in the room. There were people in the room who say Weiss was suggesting, and even the Ways and Means came out with this testimony,
Bill
saying
wanted
they
to say
wanted
something
to look
too,
at felony charges. So again, I think as we look at this case holistically, Bill, and as you know, there's been a lot in the past few days where people have come forward with intimate knowledge of this case in the past 5 years and how it was or was not investigated.
And guys, we should listen to them, okay? You're going to hear this, and I said this when the Hunter Biden laptop scandal came out, and people weren't talking about it, and people on my side said we shouldn't look at it. We should look at all of this, okay? But I think we have to trust in a bipartisan system that exists. We have a Trump-appointed prosecutor, and we have a Trump-appointed judge right now, and a Biden-run justice system. By the way, that may change as well. And what I'm looking at right now is there are whistleblowers, and they have a forum to talk about it. We haven't seen smoking gun facts yet. We've seen allegations. And I'm going to go back to this one other point and just these diversionary programs and why these are important and why the facts do matter here. Race is not the issue here in this one. And I do agree that there are disproportionate impact on different races related to these things. But we shouldn't waste the justice system's time on stupid things. On a nonviolent gun charge, he deserves a diversity program, whether he's the president's son or some guy walking on the street. And I'm not a gun rights guy. I'm not a pro Second Amendment guy. But that makes sense to me. That makes sense to me that we're not going to be going after somebody and prosecuting them and wasting the court and the justice system's time on something that he is a nonviolent person. That makes a lot of sense based on the facts.
Bill Caruso and Aaron Elmore.
Leave it there. Thanks.
A lot of breaking details right now involving the deal and Hunter Biden. We appreciate you both joining us as